Hello and welcome, everybody. We're going to just show a short video as people start to come into the room. So there's some food and drinks here in Jenner. And for those of you at home joining us from home, thank you. But we're going to show a short video just to kind of warm up today.
Yo tengo un sueño muy grande y yo me quiero convertir en un artista. Aunque he escuchado que del arte no se puede vivir, yo sí me imagino una vida viviendo del arte, porque realmente tengo un sueño y siento que los sueños se pueden hacer realidad. La razón por la cual yo vine a este país principalmente fue porque durante el tiempo que viví en Colombia, desde muy pequeño, siempre viví con el miedo de ser homosexual.
NIJC facilitated the introduction to Camilo, and Camilo was in need of immediate legal assistance because his merits hearing was coming up. He was denied asylum at his initial asylum interview, and his case was referred to immigration court. And so the challenge was working with him to figure out what facts might not have been included in that initial interview, which were really relevant to his application for asylum.
Tuve la oportunidad de conocer a las abogadas y desde el primer momento fueron más como unas amigas porque cada sesión fue muy emocional.
Our asylum system demands that asylum seekers share some of the most intimate details of their life with complete and total strangers. And as an attorney, not only are you helping prepare the legal case, but you're really helping prepare your client to be able to do that.
The moment that we were told by the immigration judge that Camilo had been granted asylum was one that I will never forget.
Desde ese preciso momento mi vida cambió. El tema de haber solucionado mi situación legal en este país me dio la opción de que no simplemente se quedara con la intención de vivir acá, sino darle un propósito.
It can all sound very daunting, but I think as a trained attorney and with the support of NIJC, you absolutely have the power to make a difference.
NIJC, I believe they transformed the world. I was able to benefit from that, and the NIJC also helped me with the family petitions. And so my 3 kids and my wife joined me in Chicago, and that was the happiest day of my life. Since I got my asylum, I started volunteering my time with National Immigrant Justice Center, doing interpretation for East African communities. And I saw the importance of trying to set up a place where those communities could meet and exchange ideas. And we came up with this idea of opening the restaurant.
The community come together. People just come and relax. People talk, people chat. Whoever is new in the country, we have to help. So they come here, we help them up.
Well, speaking of experience from my own life, I would say the sky is the limit in this country, and the compassion of the American people was very important to me, and this has kept me going, given me more strength to become a good citizen and a good member of the society. My hope is to continue what I'm doing, especially with the immigrants, so that they will become contributing members of the society. That is the whole aim why I wake up every day and do this.
Great. Hi, everybody. My name is Hope Tone O'Keefe, and I'm an associate here at Jenner, and I'm also a member of NIJC's Associate Leadership Board. We are very excited to host this training for NIJC this month. We do a lot of important asylum work at the firm. We represent our clients in a variety of different asylum proceedings. I myself have done many merits hearings, and I think I have 5 active asylum cases. We're very happy to devote our time and energy to do this very important work with a very important organization. And so we're very excited to have you here this month for this training. And so we're going to kick it off. Thank you.
Thank you so much. And thank you to Jenner and Block for hosting us. Give me a second, and I'm going to pull up the PowerPoint that we're going to be using today.
Okay. Good afternoon, everyone. My name is VanderLinden. I manage the LGBTQ team at the National Immigrant Justice Center. And thank you for joining us here today, either here in the room or online from your homes. Again, if you're in person, Jenna has lovely provided us some snacks and drinks the back and the sides of the room. I'm going to note the QR code on your screen. You will need to scan that to sign in for attendance purposes, but for more importantly, for CLE purposes. We're going to have 2 CLE codes throughout the presentation. You'll need both of them to get CLE credits. And we are going to be recording and posting this training, but just a reminder, CLE is only available for live attendance. So unfortunately, watching the recording later will be wonderful, but won't get you that CLE credit. So again, I just wanted to thank Jenner and Block for hosting us, specifically Angelina Smith and Noura Maznavi, and really all the pro bono leaders here for hosting us and for all of the efforts that they've put into representing asylum seekers, but especially LGBTQ asylum seekers throughout the years. Okay, well, the agenda slide's brief, but we are in it for about 2.5 hours of jam-packed fun this afternoon. So we're at part 1, welcome, and I'm going to give a brief introduction to NIJC. But as you see, we will go through different facets of asylum law, that legal framework for getting people protection, and then also some practical tips, both on working with the LGBTQ community and also preparing and presenting real life asylum cases. So I just want to see in the room, has anyone in the room ever worked on an asylum case before? Yeah, I'm seeing some folks. And for those of us joining online, we have both a chat and a Q&A function. So please openly use that chat function to share your experience. But if you have questions throughout the presentation, drop them in that Q&A box so that we can be able to get to those at the end. I also want to give the unauthorized practice of law advisory that this presentation is intended to assist attorneys and accredited representatives in preparing asylum applications, and it is not intended to assist others in providing legal advice or in the unauthorized practice of law. So, who is with us today? First one's me. My name is Lee. Again, I use they, them pronouns, and I am the managing attorney on the team. My colleagues at the table, Moises Lopez Soltero, uses he, him pronouns and is the pro bono coordinator. So when you take a case, you will be speaking with him. And we're also joined by Katie McCoy, who is a staff attorney and Schreibner Fellow on the team. Virtually, Olivia Judd is managing attorney of both the LGBTQ and the Asylum's pro bono projects. So she is helping us from the web and will be the one managing that Q&A function in the Zoom. Okay, so a little bit about us. The National Immigrant Justice Center, we work to ensure justice for immigrants, refugees, and asylum seekers. And we've been doing this work for almost 40 years. For those of you all who were able to join us at the Human Rights Award, it was our 25th year of that program. So we have been developing our model for quite some time now, which is really in communication with other parts of the organization. By that, I mean, we have direct legal services, and that's where I work. And that's where the pro bono model of helping and taking on some of these asylum cases is. But then we also have federal impact litigation, as well as policy and advocacy. So, our policy work and our advocacy work both is informed by and assists in that direct legal representation. So that I just think it's a really beautiful way to be able to work with people at the level that they're at while also pursuing the systemic change.
And we are only able to take on so many layers of this because of the help of our really robust pro bono network. So we have about 2,000 pro bono attorneys that are taking cases. And what kinds of opportunities are there? See the slide above. No, there's just a lot of different types of cases that pro bono attorneys can help with. Today, we're focusing most on LGBTQ immigrants, but there's also opportunities to be involved with other types of immigration relief and even with clinics. Especially with our recent arrivals, there have been many models of more pro se clinic type work as well. And another plug for really stepping up engagement and taking on a pro bono case. It helps more than just that client that you are representing. So this one-for-one idea, one person that you're able to represent frees up capacity for yet another immigrant to be able to access services. And especially in asylum work, it's not just benefiting that person being granted asylum. There are ways that that person can then petition for their family members. And then, lawyers, right? But there's a way in which that case law is and can be developed. One of the cases that we will talk about a little later was presidential Seventh Circuit published opinion case that arose from NIJC. So taking on these cases and vigorously litigating them is one way to help establish case law that it benefits the whole variety of folks who are seeking protection-based relief. So you're excited, you're fired up. How do you do it? So we'll talk more about the nuts and bolts, but the process goes that someone seeking immigration-based relief contacts NIJC, and then we do an intake with them. We assess the strengths of their case, what relief might be viable for them, and then we sign a retainer with the client, and then we try to place them with a pro bono attorney. If a pro bono attorney is able to accept the case, then we are still of counsel. We are here to support. We will provide technical assistance. We review documents, answer any questions along the way, and really walk with the pro bono attorney throughout the pendency of that case. Part of that assistance is we have a lot of print resources too. Even just on our website, we have we have manuals, we have sample documents, country condition resources. We will talk a little bit more about some of those in depth later, but I would really recommend turning to those materials because especially the asylum manual, it has a lot of questions answered in it right from the get-go. So some cases, we just put up a couple of examples of the about 20-ish cases currently on the list of individuals who need representation. So you can see we are working with people from countries across the world and a variety of really harrowing circumstances that led them to flee their country of origin and seek safety in the US. There's a link at the bottom of this slide where you can access the full list that has a full case description. One more plug. Why do this? Why is the pro bono network so incredibly important? You can see this graph, grant rates. So the ability to access counsel and have an attorney represent you in your immigration proceedings is just absolutely differential in their outcome. So last month, the New York Times put out a little article and it really highlights the ways in which now the ability to access immigration counsel is even less than it was a couple of years ago. So the factoid there is now only about 30% of migrants are able to find a lawyer to represent them. And about 5 years ago, that number was 65%. Now, I'm a lawyer, not a mathematician, but the ability of access to counsel is even more scarce than it has been. And when you do have counsel, the grant rate just almost doubles. So it's just very important that we have smart, motivated, dedicated, passionate people like yourselves who are able to use their time and energy to represent asylum seekers. Now, I am going to pass it to my colleague Moises, who's going to lead us through a little bit of an LGBTQ 101.
Amazing. Thank you so much, Lee. So the objective of this section is to discuss concepts and terminology regarding sexual orientation and gender identity. Many LGBTQ individuals have specific stories of harm that have forced them to flee their countries of origin. With this in mind, we have prepared the following resources to support you in becoming strong LGBTQ advocates. So we'll begin by discussing LGBT terminology and focusing our attention that it is constantly evolving. Some individuals may use terms differently than those listed here. They may use combinations, or they may also use different variations. If you're unfamiliar with someone's identities, it is a really good opportunity to lean into curiosity and give them the opportunity to share about their experiences. Validation of someone's identity is extremely pivotal in any relationship that you build, and especially with your client. So one way to validate an LGBTQ asylum seeker's experience is by familiarizing yourself with appropriate terminology. For example, our project cautions against using homosexual or homosexuality as it was previously used in clinical settings to make LGBTQ people believe that their sexual orientation was a disorder. And you can avoid putting another person down by asking them their chosen name and pronouns. If asking about gender or pronoun identification causes confusion, explain that this is a standard question that you always ask and give examples. Mistakes happen, and that's okay if they do. Respond and react respectfully. So there are a whole bunch of different lenses that you can use when talking to clients, so it is important that you do not assume their identity. You might meet a client for the first time and assume their gender expression based off of their appearance, but that does not mean that you know their gender identity. Now, sexual orientation and gender identity can be a difficult topic to discuss, but it is really important that you consider it when preparing an asylum application. Please note, sexual orientation and gender identity are not the same. For example, trans people can identify as straight, bisexual, gay, etc., and may go through a period in their life in which they have identified as lesbian or gay before coming to terms with the trans identity. Others don't. Gender affirming care can be life-saving for many people, so it is critical to familiarize yourself with transgender specific terminology. Here we have listed transition, hormone replacement therapy, and gender confirmation surgery. While the definitions are listed here, we really want to emphasize that not every trans person takes any or the same steps in transition. This is a highly individualized process for everyone. And it is really important that you are able to communicate with your client about what steps they have taken or wish to take to receive gender affirming care. Language evolves, and we are not going to be able to cover every aspect of an LGBTQ case in this presentation. So we have included additional resources and encourage you to continuously stay informed. And now I'll pass it over to my colleague, Katie, to discuss asylum law.
Thank you. Okay, we're switching topics a little bit, and we are going to do an overview of asylum law. The objective of this section is to provide a high-level summary of the elements of asylum law and to go over what are the basics. I will note that this is the present state of asylum law, and we are not addressing any new policies or changes that may or may not have been announced last week. Asylum law rapidly changes, so it's very important to stay on top of whatever the policies are. We will help you with that. Right now, this is the current state of the asylum law.
So the asylum definition is actually based in international law and was codified in the Immigration and Nationality Act. The difference between a refugee and asylee, a refugee is seeking protection outside of the United States, and asylee is seeking protection in the United States, but it's the same definition. And there are 5 elements that you need to pay attention to. We'll get more in depth later on in this presentation, but so you know, it is that someone has faced persecution, which is a certain level of harm in their home country on account of one of these protected grounds, which is race, religion, nationality, membership in a particular social group or political opinion, and that country of origin was unwilling or unable to protect them. This can be past harm or it can be future harm. Who is involved in an asylum case? Immigration cases can kind of feel like alphabet soup sometimes. There are a lot of acronyms and a lot of different agencies that are involved in an asylum case. The ones that are most important and that you would need to know is the Executive Office of Immigration Review, which is the immigration court, which is housed within the Department of Justice. And then the appellate body of that is the Board of Immigration Appeals, which is also an administrative agency within the Department of Justice. We're focusing today on defensive cases, so those are the main players that you would be interacting with if you take a defensive case. If you were to take an affirmative case, though, you might be interacting more with the Department of Homeland Security, or DHS, which houses the Asylum Office in the U.S. Citizenship and Immigration Services. There's also ICE, Immigration and Customs Enforcement, which is usually if folks are detained or placed into proceedings, or the government attorney who is arguing against your client, arguing for deportation against your client in immigration court. That's all within ICE. Or Customs and Border Patrol, that's who they would typically interact with either at an airport or at a port of entry or at the border. What we're not covering today is unaccompanied children who are in the Office of Refugee Resettlement. That's where they would be detained. It's slightly different than adults who are detained in ICE custody. And then asylum seekers themselves who have to navigate all of these different agencies, and you who are also outside of these agencies. Again, the focus today is defensive, but as a quick breakdown, all of this is still administrative proceedings, but affirmative cases are for folks who are seeking asylum in front of the asylum office. This typically means that they entered with some sort of status and then are seeking asylum, or for whatever reason are not placed into removal proceedings. They were not apprehended at the border. And so they would first present their case with the asylum office, which is a non-adversarial setting. That means that it's just an interview that is supposed to be trauma-informed and supposed to be more open and easier for an asylum seeker to share all the trauma that they've experienced in their home country. If they do not succeed with the asylum office, they're not denied, but instead would be referred to removal proceedings. Or your client, if they arrived in the United States and were immediately placed into proceedings because for whatever reason they didn't have a visa or weren't eligible to enter the United States, then they would start in immigration court, which is an adversarial setting. As I mentioned, there is an ICE attorney present who is arguing against your client's ability to remain in the United States. And you are in front of an immigration judge who is, again, with the Department of Justice. Then if you do not succeed at the defensive stage with the immigration court, you could appeal to the Board of Immigration Appeals and then to the relevant circuit court. We're going to be focusing on the 7th Circuit since that's where we reside. The sources of law, again, I mentioned the INA, the Immigration and Nationality Act. The Section 208 is your main asylum provision. And then further explaining the statute is the regulations. Again, always check these to make sure you have the correct versions. There is quite a bit of litigation on the different regulations. And then from there, you have a case law which would interpret both the statutory and regulatory provisions permitting someone to seek asylum or being eligible for asylum. So you would look first at 7th Circuit case law. You can also use BIA, again, Board of Immigration Appeals case law, which is binding unless the 7th Circuit has outright rejected it. And in the 7th Circuit, we're fairly fortunate, as we mentioned, to have rejected quite a bit of negative BIA precedent with some advocacy by NIJC and monitoring by NIJC. So please pay attention to that. And then you can look to other circuits, but sometimes that case law is not applicable and it can only be persuasive. This is what an actual asylum application looks like, regardless if you're in affirmative or defensive proceedings. This is the form that someone would fill out to apply for asylum. It's called the I-589. And it is actually a 3-in-1 type of application. And so within this application, it's not just an application for asylum, but it's also an application for withholding of removal and protection under the Convention Against Torture. And so when you fill out this form, if you fill out this form, you want to make sure you are applying for all 3 forms of relief, and I'll discuss the other 2 shortly, but you want to maximize the possibilities for protection for your client by checking off the box that says you're also seeking protection under CAT. So why might someone who meets all the statutory provisions I already laid out still not be eligible for asylum? There are certain bars to asylum. One that we often see is the 1-year filing deadline. When someone has entered the United States, they have exactly 1 year to apply for asylum. And if they don't, they would not be eligible for asylum. There are certain exceptions, and especially with our LGBTQ clients, some exceptions that we found to work are if someone is scared to come out with their gender identity or their sexual orientation because they weren't able to in their home country, and it took them time to find a nurturing community in order to do so. That might be an exception. If you have a case that has a 1-year filing deadline, we have tons of briefs and tons of examples that can help point you in the right direction for how to argue an exception. Similarly, another bar that we often see is the firm resettlement bar. If someone has sought protection in another country prior to arriving in the United States, and it's a permanent offer of residence to remain in that 3rd country, that can be a bar to asylum. If this is applicable, again, NIJC is briefing this a lot these days, and we will help you form the best arguments possible to get around this exception. So if your client still comes up against these bars and isn't eligible for asylum, which is a discretionary form of relief, they may still be eligible for protection under statutory withholding of removal, which is a mandatory form of protection. So if someone meets these statutory grounds, which are almost the same, but with a higher burden of probability of harm that someone would be persecuted if they were returned to their home country, they must be granted statutory withholding protection. So if there's a 1-year bar issue and they find that no exceptions apply, if there's firm resettlement and no exceptions apply, they would be in statutory withholding grounds. Another form of relief that often comes up if your client has some sort of criminal history, this is more commonly when someone would be applying for CAT protection. There are two forms of CAT, INA CAT or statutory CAT, and then deferral under CAT. They're similar. And so how you would determine if someone is eligible, it's not if they've experienced persecution, it's torture, which has its own legal definition, which is usually higher than persecution. But what's different and unique about CAT is that it doesn't have the nexus requirement. So it doesn't have to be on account of one of those protected grounds, which can be difficult for folks to prove at times. It can just be that they fear with 50% probability that they would be tortured if they were to return to their home country, and with the acquiescence of the government or by the government. So here's the full breakdown. Important to note that asylum is the only one that's a pathway to citizenship. Withholding and CAT are not pathways to citizenship. You would actually receive an order of deportation that is withheld or not actualized. And so the person can, in practicality, remain in the United States indefinitely with work authorization, but they can't adjust their status, they can't petition for family members, they can't vote in any elections, they can't travel abroad. And now I will pass it over to Lee to go more in depth about the elements of asylum.
Thank you, Katie.
like the slide says, the objective of this section is going to be to do really a deeper dive into the different elements of asylum, go a little bit more into the nuances of some of these legal terms of art. So again, we have in the asylum definition, we consider it in these 5 separate elements, but importantly, they are separate elements. It is sometimes easy to kind of, when you're working with a client's story, to see that story, all together and as a true story that it is. But when making that legal argument, it's our job to parse through each of these elements specifically. So first element being that there is a well-founded fear. And you can establish a well-founded fear in 2 different ways, both by past harm and by future fear independently. So the past harm piece, you would need to go through all 5 of those elements on the previous slide to say that someone experienced harm that rises to the level of persecution that is connected to protected ground, and that the government can't and won't protect them. So if you can establish through an entire asylum case by what happened in someone's past, then you get what's called a rebuttable presumption of a well-founded fear. If for whatever reason you can't make the argument for past harm, then you can still be granted asylum for just a future fear. But unless there's really no past harm at all, we strongly recommend that you would make arguments as to both. And as Katie mentioned a bit earlier, the burden of proof that we're dealing with here is a reasonable possibility. Case law says that is a 1 in 10 chance. So 10% likely to be harmed in the future, which can sound pretty attainable, but as we're doing this deeper dive, you'll see that the elements here are, can be really tough to prove when you're trying to get this entire argument laid out. So again, like I mentioned, if you're basing this on past persecution, you argue as to all 5 elements, and then you get that rebuttable presumption. But since it's a rebuttable presumption, what actually rebuts it? These 2 options. So importantly, the government would need to rebut. Since we're talking in defensive land here, we are across the table from the government, and then it is their burden to rebut the presumption of a well-founded future fear. And they can do it in one of 2 ways, either demonstrating that circumstances have changed more likely in the country of origin, or by demonstrating that there is a safe and reasonable internal relocation. So if you have, let's say that we're working with a client from Colombia, and we have proven that they are qualified for asylum going through all those 5 elements, the government can say, well, they left Colombia in 2017, and now it is so much safer for an LGBTQ person. They have to prove that, and they won't be able to. They could also argue that, oh, well, they were in a really rural area, and if they just moved to Bogota, then they'd be safe. So, but the relocation has to be both safe and reasonable. So there are many arguments that we can put forth saying, actually, it's not safe to be a queer person in Bogota either, or that it's not reasonable because the Colombian government is involved in harming the LGBTQ community. So again, there's ways in which there's this kind of point counterpoint argument for all of these elements. If we are just arguing future fear only, which we will do in conjunction with past persecution if we can, we argue these 3 parts of it, that the person's fear of returning is subjectively genuine, and that it is an objectively reasonable fear. So oftentimes we'll use country conditions articles showing that based on these reports documenting the types of harm the queer community faces, it is objectively reasonable for someone to fear persecution if returned to that country. And then again, in this context, we will argue that there is not safe, reasonable internal relocation. And by arguing all three of those points, that can form the basis of asylum only based on a well-founded future fear of persecution. So I've thrown out the word persecution quite a bit. What does it mean? The law says, kind of. So again, it's another legal term of art that has a lot of ink spilled on what actually can rise to the level of persecution. What type of harm is sufficient to meet this legal term of this legal definition of what persecution is? So we have generally these three types: significant physical force, infliction of comparable physical harm without the direct application of force, and non-physical harm of equal gravity. So we see a lot of different types of harm that are inflicted on LGBTQ asylum seekers. It doesn't always have to be someone being beat up or having scars from an attack, but that can certainly be in that first category of significant physical force. We sometimes will also argue that the non-physical harm, like how Katie mentioned earlier, being scared to come out in the 1-year filing deadline context, we'll sometimes argue that the homophobia or transphobia in someone's country of origin caused psychological harm that does rise to the level of persecution. Unfortunately, with a lot of our clients, many people have experienced childhood sexual assault. So that's kind of in the middle of this slide. We have case law saying that the harm that happens to a child does not have to be as severe as harm to an adult to be able to rise kind of to that threshold of persecution. An additional point here is that the harm has to be considered cumulatively. So as to say, if there were many instances of harm that may not be severe enough to individually rise to the level of persecution, the immigration judge needs to consider cumulatively if taken together, the harm is severe enough to rise to the level of persecution. So lawyers, right? We have a hypo. So we're going to come back to this story a couple of times during this part of the presentation. So I'm going to read it aloud with us for this time. So Bernadette, who uses they, them pronouns, is a queer, non-binary person from Ghana in removal proceedings. Bernadette was assigned female at birth and was generally perceived as a woman while living in Ghana. Around 2018, Bernadette began volunteering with a Ghanaian organization that works on advocating for LGBTQ rights and HIV prevention. Bernadette taught sexual health classes at clandestine meetings and sometimes helped the organization with administrative tasks. In 2022, neighbors obtained photos of Bernadette and their girlfriend being affectionate together after Bernadette's girlfriend took her phone to be repaired at a local shop. Bernadette's parents forced Bernadette to marry a man who prevented Bernadette from leaving the house, beat them, and raped them. With the help of their sister, Bernadette escaped Ghana in 2022 and flew to Brazil. Bernadette spent 1 year in Brazil, where they received a temporary work permit. However, they felt forced to hide their sexual orientation and gender identity and did not live openly as a queer non-binary person. Also, they were repeatedly called racist and xenophobic slurs by strangers on the street, and on one occasion, they were attacked and robbed by a man using racist slurs. In early 2023, Bernadette fled to the United States and timely filed for asylum. So, this is an audience participation part. What do you think in Bernadette's story is harm that they experienced that might rise to the level of persecution? So if you're in the room, there are microphones set up in the middle. If you're virtually, put in the chat, What kinds of harm here do you think would we argue that rise to the level of persecution?
I'm not speaking. I'm going to hand the mic over. Who wants to talk?
The physical violence that Bernadette experienced, both in her time in Ghana and in their time in Ghana and Brazil.
Yeah, so definitely physical harm. What I'll say is that we would be, this will come up later too, but we'll be focusing on their time in Ghana because we would argue that they didn't have status in Brazil and so would not need to present a claim as to Brazil. I see a hand way over yonder.
Yeah, and Olivia's going to monitor the chat, so feel free to jump in, Olivia.
In the chat, I see forced marriage, not being allowed to leave the house, controlled movement.
Definitely. Yeah, so I would argue that those are in that the non-physical harm and then also kind of that psychological harm in that third category.
Oh yeah, that's what actually I want to see, like forced marriage and the rape and yeah.
Yeah, in the room with the forced marriage and the rapes, absolutely. Rape is, especially when on account of a protected ground, is absolutely persecution. Okay, thanks everyone. We are going to move on to our next element. So unable and unwilling to control. So we're looking at the government's ability to protect someone. Importantly, I fear that many people think, oh, political asylum, so the government has to be doing the harm. That certainly can be true, but it doesn't have to actually be the state or state actors. Of course, some examples of those actors are police, security forces, local leadership. We also have been making some arguments that in some countries, paramilitaries or gangs might in fact be state actors because of the level of control they may have. However, it doesn't have to be a state actor. We just have to argue that the government is unable or unwilling to control those actors. So gangs, paramilitary, family members, any other type of person who is the persecuting actor, we would just need to argue that the government cannot or won't control them or protect our client from those people. So when we're looking at unable or unwilling to control, a lot of times, how do we prove that? What evidence are we using? Back to those country conditions. We're using NGO reports, news articles to show that the government actually doesn't protect this class of people. It runs the gambit of both like laws on the books and lived realities in many different countries. So, for example, in Nigeria, there's the Same-Sex Marriage Prohibition Act. That's a law on the book that is enforced against LGBTQ people. There are other countries where there are punitive laws that may not be enforced, but we have seen there's evidence that, for example, police might use the existence of those laws to extort people from the LGBTQ community. There's kind of these facially neutral countries where there's no laws addressing queer folks. And then kind of in this last bucket, there are countries in which there are facially progressive laws, or on the books, there is tolerance. What I've seen is that, for example, in Mexican claims, the Department of Homeland Security, like the US government will say, oh, but look, trans people can change their name. Thus, the government does protect trans people, to which I usually reply with statistics about the levels of trans femicide in Mexico currently. And that we show that although perhaps there is hate crime legislation in place, there's actually been less than, I think the impunity statistics are less than 2% of successful prosecutions. So again, this is where we take those facts, apply it to the law to make the argument to say, even in countries that have facially protective laws, the government still is unable or unwilling to control transphobic, homophobic, anti-LGBTQ violence. And I'll note here that as part of the assistance that NIJC provides to pro bono attorneys, for LGBTQ cases only, we are able to give country conditions packets. So index and all of those articles that can help evidence these types of elements and in these types of claims. Okay, back to the hypo. So who are the actors here? Who are the people who are on, from this 2 slides before, who are the entities that have caused Bernadette harm?
Family members is one.
Family members, yep.
Get 2 going here.
Yeah. Do we have some ideas from online as well?
None yet. I will let you know if I see anything come up in the chat.
Thanks, Olivia. I see what in person, yeah.
The man that they were forced to marry.
Mm-hmm. So family members, the husband, what do we think? Are these private actors, state actors? Probably private actors, right? So this is where we would make the argument that the government would be unable or unwilling to control actors like that, or that the government is not protective of an LGBTQ person. Okay, this element, this one, guys, this one's a biggie. This on account of element is super important because it's not enough to show that someone has been harmed and that harm rises to the level of persecution and that the person who did that harm is an actor that basically that qualifies. You have to show nexus. So this is a term of art that means on account of. So you have to show that the person, like Bernadette, was harmed on account of a protected ground. So there's definitely a circuit split on this question of how big of a reason, how primary of a reason, what do you need to show the reason? In the Seventh Circuit, we are in the one central reason land. So it doesn't have to be the pure only motivation, but we do have to show that they were motivated to harm this person because of a protected ground. So the nexus being that connection between the protected ground and the harm. How we prove that is using things like circumstantial evidence, timing, the words of the attacker. So did the attackers, if someone was being beaten, did the attackers use homophobic slurs? Did they make any sort of statements about someone's gender conformity or nonconformity? Is the timing, maybe someone was attacked after leaving some sort of LGBTQ support group meeting? What facts can we use here to show that there was this connection between someone's LGBTQ identity and the harm they suffered? Hypo time again. So in our story about Bernadette, what facts can you imagine that we would be able to use to show that connection between the LGBTQ identity and the harm?
I think probably the neighbors taking photos of Bernadette and their girlfriend being affectionate, and then this leading to Bernadette's parents forcing them to marry the abusive husband.
Yeah, absolutely. So that timing that this thing happened that outed their LGBTQ identity and then the resulting harm. Yeah. Any ideas from online so far?
Nothing yet.
Yeah, so I think that, I can imagine, I'm not I'm not sure, but I could see that there would be a possibility that their family would say, oh, you need to get married because, women should marry a man. Or maybe that when they're in the forced marriage, when their husband raped them, they said, well, this is what a wife should do, making reference to their sexual orientation and gender identity. So we would use things like timing, like the words that the attackers used, to show again that connection, that on account of harm and the protected ground. Speaking of protected ground, Katie read through them earlier. There are 5 different protected grounds. So you can see here, race, religion, nationality, political opinion, and this last one, membership in a particular social group. I do want to say, though, that a lot these tend to have a pretty broad meaning. So especially in religion, I've had some cases where someone was agnostic, or an apostate of Islam was a type of religion argument that I've made before. And then for both political opinion and membership in a particular social group, one thing I want to highlight is that it can be imputed. So it's not just that they are actually having a political opinion contrary to the government, but maybe they didn't go to a protest, and for that reason, people harmed them because of the political opinion that they believed to have. By not going to a protest, then it's imputed that you're against, or I'm sorry, by not going to maybe a government march, then it's imputed that you have a political opinion against the government. So it doesn't have to be an actually held political opinion or an actually held membership in a particular social group. It can be imputed. So membership in a particular social group, yet another legal term of art that means nothing and everything all at once. LGBTQ cases do fall in this bucket. And fortunately, they're pretty much nationally, but definitely here in the 7th Circuit, sexual orientation and gender identity are widely recognized as cognizable political social groups. Particular social groups, my apologies. There are different circuits, though, that have different components put forth by the BIA, like visibility, particularity. There are different places in the country where proving that a particular social group is cognizable is harder. But here, sexual orientation, gender identity are cognizable particular social groups. One of those NIJC cases that set case law here in the 7th Circuit is under that second bullet point, Velasquez-Venegas. And again, this is where this imputed sexual orientation comes into play. So that case was about a heterosexual cisgender man who was living with HIV. So it was an imputed case because he wasn't gay, but people in his community believed he was gay because of his HIV diagnosis and harmed him because they believed he is gay. So that is one type of an imputed argument. We also have folks who are within the LGBTQ community and are also HIV positive. So there are different types of arguments you can make there as well. When you are working with gender identity, I do want to note that the case law that is published has terminology that we wouldn't use. And so earlier when Moises was talking about how language evolves, this is one place in where you will get some tips from Moises later about how to craft those arguments using the case law that we have, and also language that is affirming and respectful. Okay, we are nearing the end of this section. Do not worry. One more time for the hypo, though. When we're presenting Bernadette's case, what types of protected grounds would apply? What would we argue that their protected grounds are? I saw a hand over there.
Actually, I got a question.
Oh yeah.
So, I don't know if you already touched upon this, but I mean, I worked for like a asylum case before, but I remember like because they claim their asylum based on their suffering, their in Ghana, but they actually escaped to Brazil first and then come to United States. Because I remember you can't do that. You like it need to be directed from the country like Ghana, then to United States. Like because United States may why you do not apply for asylum in Brazil. So that's my question.
Yeah, definitely. I'll address that real quick, and then maybe y'all can start brainstorming some protected grounds for Bernadette. So the question was about, but what about this Brazil fact? Why is it that the United States would say, oh, you should have applied for status in Brazil? And that is exactly right. That goes to that firm resettlement bar that Katie mentioned earlier. So basically, if someone resided in a country for a while, maybe had protection in that country, they would be barred from asylum unless an exception can be met. Here, we would argue that they were not firmly resettled because it was a temporary status, a temporary work permit. I don't want to go like too into the weeds on this point. So how I would argue is first, they were in fact not firmly resettled because there was not a firm offer of permanent residence. But even if they were, there are exceptions that apply. So even if they were firmly resettled, their residence was, I'm just throwing the legal words out, but so restricted such that their resident was constricted by the state. So we would use facts about their treatment in Brazil, how they felt that they were forced to hide their sexual orientation and gender identity, that they experienced racism and xenophobia, and they experienced physical harm. So kind of an asylum light analysis of the conditions of their residence were so restricted that the firm resettlement bar shouldn't apply. But you're right, we would have to make those arguments as to their time in Brazil. Oh, is that a hand? Okay. Thank you.
So for the protected grounds, I have an answer, but it also leads to a question. I thought that, well, Bernadette could have the protected grounds based on membership in a social group because they are queer, or they're queer and they're non-binary, so that could apply to, so they can get protection because of that, especially because it seems like that's the reason why they were married off to an abusive husband, and then they suffered from a lot of racist and xenophobic slurs, but that does not seem to deal as much with sexual orientation or gender identity. But then I was also thinking, because they advocated for LGBTQ rights and HIV prevention, that was more of a political opinion, but I don't see anything that shows that was why, that they were targeted for that reason. So I was just worried there wouldn't be a nexus there.
Your worry is a good one. So that's how I would see it too, that there's that PSG or particular social group around their LGBTQ identity. And I would also argue that there is a political opinion there based on that advocacy. What we would have to do is we'd have to work with Bernadette and say, hey, did anything bad ever happen while you were working with this group? This paragraph can't be their whole story, right? We would work with Bernadette to kind of through some interviews, and we'll talk about some of those techniques later on, about what else might have happened in their life that we could argue is harm that rises to the level of persecution with that nexus to the political opinion. Maybe there isn't, but that it would be a road in which I would want to get some more information. Yeah, Hope.
So mine's a bit of a question. What I guess I've done a lot of like South American asylum cases, and we often make an argument about domestic violence. and that rising to the level of particular social group. And so Temi identified some really great potential protected grounds, but then even independent from those, is there perhaps, I mean, it would take interviews with the client, obviously, some sort of protected ground related purely to the fact that she was like a victim of a domestic violence and a forced marriage, just as being a woman? Or is that like with recent changes? I mean, it's always been an uphill argument, but is it even more of an uphill argument is my question.
It may be more of an uphill argument, but my approach is if there's a viable argument, we make it. So we might argue that they were viewed as a woman in a relationship that they could not leave. And that kind of that domestic violence type argument that we would make. I think that both that PSG and the LGBTQ PSG, we can make both of those arguments.
Actually, I have another question is, I remember there is another classification in the US immigration law. It's called Battered Woman Victim Act. So VIMA. Actually, my question is, yeah, it's related to the question just raised. Would it be possible to classify this case under the VIMA? So like V visa, or I don't remember that one. So that kind of visa specific provided for the woman who is first into marriage or who is a victim of human trafficking. But this seems an asylum case. So I want to know whether there's a differences between these two type of cases. And when you approach this type of cases, how you choose the path, if it's different. Thank you.
Yeah, so there is a type of immigration protection called VAWA, Violence Against Women Act. And then there's also things like the T visa for survivors of trafficking and U visas for survivors of qualifying crimes. Those acts need to occur within the United States. So that's kind of what differentiates an asylum case where we're talking about harm that occurred in a country of origin with other types of immigration relief, which is usually harm that occurred within the United States. So there could be possibilities if Bernadette, for example, was in a domestic violence relationship in the US, that could open other pathways to them.
Yeah, we're going to use the mic just for online people so that it transfers. Thank you. No worries.
Just because going back again, it seems like there's like Bernadette has a lot of protected. Actually, it seems like all of these honestly could apply to them. When you see cases like this, you said that you try to just use any argument you can. So does that mean, so does that include arguing that that your client falls under certain multiple different types of protection?
Yes, I would. One thing to clarify here is that we wouldn't make arguments as to Brazil. So unless we really have to. If we change our hypo to say that Bernadette was a dual national and they had citizenship in Brazil, they could still seek asylum in the US, but they would have to basically do two different asylum cases, one as to Ghana, one as to Brazil. So we could do their particular social groups of kind of this DV one and an LGBTQ one plus political opinion in Ghana. And then we could do the PSG of LGBTQ identity plus race as to Brazil. So we would be able to argue multiple protected grounds if we have to.
Thank you.
Okay, I am going to recap us of these 5 different elements. And, as you've heard, there's quite a bit of nuance here. So the ways in which that you're preparing an asylum case it can be complicated, and there are a lot of different arguments that are open to you. We have to go through all 5 of these elements of a well-founded fear, thinking both of past harm and future fear, of persecution, so types of harm that rise to the level of persecution, that are perpetrated by the government or an entity that the government can't or won't control. So thinking about those different kinds of actors and the country conditions that we would use to prove that unable and unwilling to control part. needs to be on account of, so that nexus element, a protected ground. And we just heard that there can be multiple types of protected grounds that can apply to your client's case. So when we are thinking through all of those elements, we obviously we're using the client's life to demonstrate these, but legally we are thinking of them separately. So we are now going to take a 10-minute break. Before we do so, I do want to again thank Jenner and Block for hosting us here and having some snacks and refreshments in the room. And I'm currently standing in Chicago, so Central Standard Time. It is 3:04. So let us be back at 3:14 to continue on with the second half of our training. Thank you, everyone.
Okay, for people online, we're going to get started just to give a heads up.
All right. Thank you, everybody. We are going to get started with our second half by hearing from one of your own here at Jenner. Miguel Suarez Medina is an associate at Jenner and Block, and he has been involved with quite a few pro bono cases, including one that we're working on together. So he's going to take a couple of minutes and share a little bit of his experience on what working on these types of cases is like. Thank you, Miguel.
Good afternoon, everyone, and happy Pride. So my name is Miguel, and my pronouns are he, his, and I'm a corporate associate here at Jenner. So to all the transactional attorneys in the audience, rest assured you too can take on pro bono immigration matters. Between the resources at your firm and the awesome staff at NIJC, you'll be able to provide exceptional representation to your clients, and you'll do just fine, I promise. So by way of background, I got involved with pro bono immigration work for two reasons. First, I'm an immigrant. My family and I became naturalized US citizens just earlier this year, after about 25 years in this country, with 20 of those being in a state of rather precarious limbo. So I know firsthand that at its best, the immigration system in this country is deeply flawed. And at its worst, it forces people to go through obstacles that not only serve to dehumanize them, but all too often have fatal consequences. Second, we're at Jenner, the firm that litigated Lawrence v. Texas, that welcomed some of the first out big law attorneys here in Chicago, and that just yesterday was defending an appeal, a lower court's decision striking down the Iowa Don't Say Gay ban. When I started here, I wanted to be part of that tradition, but going back to my corporate roots, the work that goes into impact litigation is not of interest to me. So when presented the opportunity to split my 1L summer between Jenner and NIJC's LGBTQ rights initiative, I jumped on it. On day one, I was presented the case I'd have ownership over. Our client was an 18-year-old transgender woman fleeing from a Central American country, in deportation proceedings and seeking asylum. Sending her back was likely a death sentence. Now, to be sure, we're not giving the intern a 50-50 case. The facts were horrific, but that made our asylum claim a strong one. But so much of the initial work that I did was focused on getting her to trust me. In many ways, she was just like any other 18-year-old child with dreams and aspirations, and albeit a silly sense of humor. But at the same time, she was a really traumatized child who needed me to meet her where she was at. Slowly but surely, we developed a rapport that allowed us to piece together and present a compelling narrative to the court. And I'm happy to say that she was granted asylum. Now that I'm a few years into my career at Jenner, I've had the privilege of being the lead or supporting associate at about half dozen asylum cases, as well as other immigration-related matters. Now, as much as I'm pleased when our good corporate clients either make a lot of money or we save them a lot of money, nothing quite compares to the satisfaction I feel when attaining favorable outcomes for my pro bono immigration clients. Like, for example, when I received an email from a client after she learned she had attained US citizenship. In her email, she thanked me not just on her behalf, but on behalf of all the generations that would come after her. So I end with a quote that's found in both the Talmud and the Quran, and which roughly translates as, "One who saves a life saves the world entire." So I hope that many of you, if not most of you, if not all of you, will heed this call to save the world one case at a time. Thanks, everyone.
Thank you so much, Miguel, for being a champion for so many of our clients. We're so grateful for your work. I'm going to give the first CLE code, and that is ALLY, A-L-L-Y. Again, ALLY is our first CLE code. So, kicking off our next section, we are imagining that you have now accepted a case with NIJC. Congrats to you, congrats to us, hooray. What do you do? Here's what we do. So think of yourself, a pro bono attorney, as a bridge for asylum seekers, people who have many other things going on in their lives, and not just the fact that they are seeking asylum at this moment in time, with these two or many different agencies, a very convoluted, very complex, very messy, and often not very kind immigration system. You are the bridge through these systems. Again, our focus is on defensive cases, but we are flagging that we have affirmative cases as well as defensive cases. So if you think litigation's not my speed, I don't want to do that, I would rather do an affirmative case, you can, we have those opportunities available. But I also want to stress that immigration court is not the same as Article 3 court, because it is an administrative proceeding. You don't have to necessarily have tons of experience litigating a case, because, for example, the federal rules of evidence don't apply in immigration court, and a lot of other things that you might think are applicable or you need to have are not as necessary for immigration court. What's most important is that your client has an advocate standing next to them and can rebut anything that the trial attorney is saying against them. So if you want an experience that is less scary than another type of litigation experience, I do encourage you to take a defensive case. How do I know if my client is in removal proceedings? I've been talking about these two different processes, affirmative versus defensive. I will flag, we will tell you if we have already screened the case and assessed if it's affirmative or defensive. But so you know, if you are looking through the documents, there's one that looks just like this that's called the notice to appear, which is the charging document, which says that this person is removable or deportable for XYZ reason, usually for entering without inspection or for not having a visa at the time of entry. And once this is filed with immigration court is when immigration proceedings begin. This doesn't happen 100% of the time, so it is possible that your client has the notice to appear but is still in affirmative proceedings. Those are rare cases. Again, we will tell you. Your immediate steps after you take a case would be step one, read our procedural manual that tells you everything about asylum representation, much of which we've covered today. And we'll send you a case file that summarizes everything we've done so far with this client, including summarizing the intake that we did, assessing their basic facts and why we think that they're eligible for relief. In some cases, we may have already filed the asylum application, and in other cases, you would be filing the asylum application, but we would tell you where procedurally your case is. If you are in removal proceedings, you will have to register with the immigration court in order to make your appearance. There is an e-registry process, and then you would file what's called an E-28 of notice of appearance on behalf of your client. And we would flag any urgent deadlines that are coming up. Is your client close to that 1-year filing deadline and needs to have their application filed stat? Are they about to be eligible for a work permit and need to file for that so that they can have access to housing or something else? Is there a court date that's coming up, a master calendar hearing, which is more of an initial hearing, or the merits hearing, which is when the actual proceedings would go on, when your client would give testimony and you present the case for asylum? Flag all of these things. I will also say if you're a deadline-oriented person like myself, you should pay attention to whether this is a newer case, which means you can electronically file, or if it's a paper case, which means you either have to prepare a paper filing that you march down to the immigration court here in Chicago, or you prepare in advance to send in advance of the filing deadline. When you're obtaining your client's immigration history, unlike other proceedings, there is no opportunity for discovery. This is something that you have to do affirmatively on your own time. And so the process for that is typically doing a Freedom of Information Act or a FOIA. You would start with a USCIS FOIA, which I know said is the affirmative proceedings part, but that will also get you all of the information of any interaction someone has had with the Department of Homeland Security. So that usually includes border interactions, if they've had what's called a credible fear interview, kind of initiating this sort of asylum process and placing them into proceedings. Any kind of conversation that your client has had with a government entity, you want to make sure that you have access to that, you can verify that, and you can make sure anything you're submitting is not contrary to that information. If your client is in removal proceedings and has already had hearings, for example, you might want to request to review the court file. If it is an electronic case, as soon as you enter your appearance, you would have access to that. But if it's a paper case, you have to go to the court and request a file, or the hearing tapes themselves if you want an audio recording. And then if you are working with an unaccompanied child, which isn't as common with our cases, but you would want to request the ORR file of everything that occurred while they were detained in their child jails. And then one part of the process is the biometrics request, which is a background check that is conducted on your client. They have to clear this background check in order to be eligible for asylum. In defensive proceedings, it is on the client or the respondent's responsibility to request this appointment. They are significantly backlogged. So as soon as you receive this case, you would check and see have they completed the biometrics component of their case. And then you would request if you haven't yet, or then you would ask to have them refreshed. If they have not had this process completed by the time of their merits hearing, the court can deem the case abandoned, even if you went through every step to try and get the appointment set, and then there was a significant backlog and your client wasn't able to complete it before. There are some exceptions, but we would like to avoid this if possible. So if you have a case that has not yet completed the biometrics appointment, request early.
Okay, when you said the biometrics needs to be refreshed. So I, for example, like many Jenner attorneys, have a number of asylum cases that we got 2019, 2020, and we are like on third rounds of reschedules. And so is there a time at which the biometrics, separately if you get biometrics for EAD, the biometrics for a merits hearing expire? Or like when you say refresh, could you give a little more detail on what that means?
Yeah, it's, they used to not be able to refresh them. So we used to not be able to have this process. Now you can email OPLA, the trial attorneys from ICE, and ask them to refresh them. They ask that you do this about a month in advance of the hearing. We would do it around 3 months in advance of the hearing.
And how old do the biometrics need to be to require they be refreshed?
I actually don't know, but I always ask
just
to
ask
make
no
sure
matter
that
what.
they are, yeah,
Got
current.
it. Thank you.
What do you do on your first client meeting? Typically, we encourage the first meeting to be more small talk rather than diving right into all of their trauma and all of their past harms. Get to know your client. Try to build that rapport that Miguel referenced earlier so that your client feels more comfortable telling you things later on. Set a plan for meeting with them later on. How are you going to talk to them? How are they going to get to you? Is your client more comfortable with in-person meetings, or does it need to be something that is virtual for them? Do they have ability to transit to you? These are things that you need to talk to them about and have a plan set up with them so that you can run through these smoothly and they feel like you know what you're doing. Moises, I believe I'm passing to you. Yes.
Okay, so I'll start by echoing what Katie and Miguel were saying with meeting clients where they're at. Yeah, I'll just spend a little bit of time re-emphasizing that before we begin to talk more about how asylum seekers' experiences are human experiences. And I say this because it is really important that you keep in mind the ways in which trauma affects the memory. And trauma can also cause memories to resurface with little or no anticipation, right? So that can happen in your meeting, that can happen via text. Essentially, it really just goes back to whatever method of communication you primarily have and that's safest for your client, right? So you'd want to make sure that you're in that first meeting, as Katie was just discussing, you want to make sure that you're establishing what is a safe way of communication for them, particularly if you're asking for their name and their pronouns, their chosen name and pronouns. You want to make sure it's safe to address them in that way in mail or your preferred method of communication. So one thing to keep in mind, particularly when meeting LGBTQ asylum seekers, is it's pretty common for them to be really excited to meet with you the first time. They're super energetic to get working on their case. Keep in mind that it's not very easy, right, to find legal representation. So if they feel like they're finally getting an opportunity to tell their story to someone that's listening, it can be really easy for them to really want to get started on their case. But as time goes on, again, life happens and trauma resurfaces. So you really want to keep that in mind as you're working with them, right? Because that can cause different, it could cause for a super high communicative client to perhaps need a little bit more time. But it's just really important that you're setting meetings in advance and setting tangible deadlines for them and explaining what's up ahead. So it is really important that everyone involved in working on the case affirms the LGBT asylum seeker. It's really important that they feel respected, and it's really important that everyone is clear. So the legal advocate, the client, the interpreter, everyone has the same understanding that the interpreter's purpose there is to interpret. So you're still having a direct conversation with your client, right? So if I wanted to ask an LGBTQ asylum seeker, what are your pronouns, right? I wouldn't look to the translator and say, can you ask them what are their pronouns? When you are, you can find yourself wanting to talk to the interpreter if you share a mutual language. But I think the importance there is really establishing a relationship between yourself and the client. And I will also note that when working on a case with NIJC, it is the pro bono's responsibility to arrange for interpretive services. However, you can always reach out to your point of contact and we can provide referrals over to you. Okay, so for this next section, the objective is to share tips for interviewing LGBTQ asylum seeker and preparing LGBTQ claims. So we'll start by giving the first tip being use the same vocabulary as your client. So it is really important for you to understand that your client's identities can evolve over time, and that's really important for you to know as a legal advocate, so that you can understand better their experiences as an LGBTQ person. So for example, one good way of mirroring your client's vocabulary is by asking them, right, their preferred or chosen name and pronouns. By respecting their pronouns, it's a really good way that you're establishing a safe, comfortable environment with them that encourages them to continue to authentically express themselves with you every time you meet. Another tip is to familiarize yourself with appropriate terminology, right? So if a client introduces themselves as non-binary and you're not familiar with what that means, that can cause the client to feel like they're not understood, and it may make them feel hesitant to share additional information with you in the future. Tip number 3, accounting for cultural differences. This one is really important. Particularly, we can even see a connection with interpretation services here. So for Spanish and French-speaking clients, it's common for them to sometimes refer to themselves as homosexual. And when we translate that into English, that means gay, and that's really important for legal writing. I will also say for cultural differences, it's also really important to understand that many clients come from family-oriented cultures, and it may be, unfortunately, that it may be the same people that have caused them harm in the past. So it can be really difficult for them to understand the purpose and having to recount that to you. So it's really, again, going back to setting tangible objectives, it's really helpful to orient them in a conversation. Okay, applying these tips. Working with an LGBTQ asylum seeker requires a lot of intentionality and care. It's really important that you continue to familiarize yourself with and use appropriate terminology. We've discussed it numerous times throughout this presentation, but it's really important that we all understand that identities evolve, and so do our understandings. It can be really difficult for a client who has gone, it's a generalization here, but that they have spent a large amounts of their a huge amount of their lives and experiences afraid to authentically express themselves, to one day come into perhaps an intimidating space and have to open up about intimate moments in their lives. So again, helping them understand why you're asking is helpful. And I will also note that if they sense that you are uncomfortable asking, it may be more uncomfortable for them to provide a response to you. And again, be sensitive, but direct and respectful, and it can help everyone achieve their goal. And now I'll pass it back to my colleague, Katie.
Okay, preparing the case. The objective for this section is, now that you have the case, how do you actually prepare it? What are the documents that you get ready to go so that you can present the strongest case possible in the immigration court? These are the three main components: the affidavit, corroborating evidence, and your legal argument or the brief. Don't think I complete one and then I go to the next and then I go to the next. Think about all three of these things in tandem, because if you know your legal arguments, you're going to build a stronger affidavit that covers all those legal arguments. Also, if you know what corroborating evidence is available to you, to your clients, you can build up your legal arguments better. You can draft the affidavit in response to these. So think of them all in tandem. Typically, though, you will start with the affidavit by getting to know your client and their version of telling their story. Credibility is so important in an asylum case. It can make or break an asylum case if the judge does not find your client credible. And credibility is determined in two ways. That's both on written statements that are submitted to the court, and then how those are consistent with any sort of oral testimony that is provided by your client at the merits hearing. They will also be paying attention to how your client's demeanor is and how they, if they have any discrepancies in dates or times. So you want to be cautious of setting traps for your clients of things that might be hard for them to remember or say exactly the same on the stand. You don't want to accidentally create a barrier to your client winning asylum because you went in a lot of specificity thinking it would be so helpful, but then your client got anxious and nervous on the stand and blanked. So how do you draft an affidavit, understanding that most of these clients are survivors of trauma? You really need to do your homework in advance of every meeting with your client. You should have an idea of what topics you're planning to cover with your client that day. And I often start my meeting by saying, hey, these are the topics I plan to talk to you about today in this order. Does that work for you? Do you feel comfortable talking about these topics with me? If you don't want to talk about one of them today, that's okay. We can talk about it another time if that works better for you. So they can mentally prepare to go through these things that might be incredibly sensitive for them. And they also have a little bit more agency in telling their story to you. Provide opportunities to empower your clients so they can tell their story as most comfortably as they can, understanding it will be very difficult for them. Trauma survivors often have difficulty giving chronological timelines, so don't expect your client to be able to tell you on exactly this date this occurred, and then the very next day this occurred, and then exactly 3 years later this occurred. a lot of things, especially traumatic events, get compounded, and it might be really hard for your client to parse out what that timeline is. So it might be your job to reorient them to a timeline. If they say a certain date or a certain event occurred and you don't really understand, if they have children, ask, was this before or after the child was born? Is this before or after another life event? Was this near Christmas? Like, what was the season like outside, if they have seasons in the country where they live in? Something like that might help them and help you give some sense of timeline, but also framing it in a way that will still be consistent with how they tell their story. When you ask questions, make them shorter so that they're easier to digest, especially if you're working with an interpreter. Things can get lost and go very lengthy if you're asking long compound questions. And make sure the questions are open-ended so you're not boxing your client into a yes/no situation when neither of those situations are necessarily correct for the experience that they have. Again, as Moises flagged, if you have to ask a question that is really uncomfortable, and you will have to ask uncomfortable questions for an asylum case, like asking about why they think someone raped them. That's a really horrible question to have to ask someone. And so it's helpful to your client to say, I'm not asking you this because I don't believe it happened, or I'm criticizing you, or anything like that. I'm asking it because it will be relevant to your case. You don't want the first time they have to answer a really sensitive, difficult question to be on the stand. So you have to do that preparation with your client. Yes, Ellen.
What happens if your client shows up with a child or a partner to the interview, like to your prep session?
Yeah, I would check with them right away if they feel comfortable continuing with the session with the child present. They might not. And so then it might be that you rearrange for another day if there isn't another like immediate option for childcare in that moment. You have to stay flexible for your client and their realities. And then last tip on working with affidavit prep is to bookend the interview. Try and start with a topic that's more neutral, more biographic, or like asking them how they are today, and then work up to something that's more traumatic, and then work down from it into something that is more neutral again. So you're not sending your client off into the world like with their trauma at the forefront of their brain, unable to interact with other things. Make sure that you're creating a plan for them to come into this space, talk to you, and feel able to move on with other things in their lives. It's not always 100% that will occur, but as best as you can to support your client and make it an easier transition. Considerations: make this in your client's voice as much as possible. Most of the time when you're meeting with your client, the goal and objective is to prep the affidavit. So you want the affidavit in your client's voice because, again, they will be the one giving testimony. And if the affidavit doesn't sound like your client, the judge is not going to believe that that is them telling their own story. You want to, as much as possible, craft your affidavit in chronological order and provide some background information as much as possible to understand the story as an affidavit, but keep in mind that you'll be providing background evidence of like country conditions that is separate from an affidavit, so you don't necessarily need to cram all of that into the affidavit itself. Cover the who, what, when, where, why, and how of every single event, and especially incidences of harm. The judge should be able to completely understand and visualize almost a movie of this event and how it occurred based on reading the affidavit. Cover every single asylum element. Make sure you have all 5 of those elements that Lee pointed out to us and explained so helpfully. And then think about length. We aim for somewhere between 8 and 12 pages, 10 being like gold standard. You don't want it to be so sparse that no one really understands what happens in your client's life, but you also don't want it to be chock full of details that will be really difficult to repeat on the stand. So make sure that you're not being too specific, but you're not being too vague. Here's some sample language. This is all telling the same fact, but in different ways. And so really make sure they're not writing it in legalese. I was persecuted. That's a big flag. A judge will not think that a client is using the word persecuted. Because I belong to the group of Salvadoran homosexuals. They probably wouldn't speak like that. A lot of people just don't speak like that. And then also the second example is using language that perhaps is not reflective of your client's educational experience or sophistication. Some clients might have more sophistication, but it should always reflect what your client's words are that they're using and how they're saying their story. But even with this one, it's very clear it's not in the client's voice. Even if your client is like speaking in very flowery language, it's still not as direct, it's still not as clear. And then also the dead giveaway at the bottom is a reference to the country conditions. You don't need to do that in an affidavit, not for immigration court. A judge will be like, an attorney wrote this, which they know anyway, but this makes it super clear that an attorney did this, not the client. Too much detail is also not helpful. So again, using specific dates, you wouldn't want to do that. And then the more balanced example around May 2010, an approximate date, giving some wiggle room, a group of gang members, not saying how many exactly, stopped me after school and threatened me with anti-gay slurs. Next is corroborating your case. You should be thinking about this the entire time, but what other types of evidence can you provide apart from your client's affidavit? By the regulations, a client could win asylum on their affidavit alone if there's no other additional evidence that they can provide, and you can explain why they can't provide it. But if you have more evidence, it's always better and more likely that you can prove your client is credible. So what types of evidence is helpful? As we've mentioned before, country conditions evidence, which would be like State Department reports or parts from international nonprofits that talk about the country conditions in their country, why it is similar to the experiences that they've faced. Think about client-specific details, which could be any sort of like if they ever went to the police, is there proof of a police report? Is there any physical evidence? Are there pictures? Do they have friends who can corroborate what they said? Is there any kind of anything else that supports their story? If there's past persecution, you might want to connect them with a mental health professional who can provide an evaluation that says, based on the story that they've told me, I think that they have post-traumatic stress disorder, and that's consistent with their story that they've told and affected them in this way. If there's physical markings or scars, for example, also a forensic medical evaluation can document that, saying like this scar is consistent with the story that they told me. And then future persecution. Think about anyone who might similarly be situated, who is in the country of origin that this person knew. Who can they say how this person would be affected if they had to return to their country of origin? And so Bernadette is back. In Bernadette's story, what do we think could be type of corroboration for their case? Anyone? Olivia, is there anyone on the chat?
Nothing yet. I'll jump in if reports on hostility towards LGBTQ people in Ghana, country conditions reports. I will go? Expert testimony.
Yes, go ahead.
If there is if maybe she went to the police in Ghana about the rape that she suffered, that can be maybe a report, or maybe witness affidavits if she told anyone she was related to, maybe told her family what was going on, and maybe her sister actually, since her sister helped her.
Definitely the sister. We would want to ask the sister.
Maybe also the photos that the neighbors obtained and then the subsequent marriage license.
Yes, absolutely. These are great ones. Any other?
Also, probably there's some, I don't know, verification or certification of their employment. So like what they did as their employment in Ghana, and then also
yes, definitely. I think that the human rights organization, the LGBTQ rights and HIV prevention could be a great source of corroborating evidence for sure. Yeah.
This is actually more of a question. Well, it's a question.
with this corroborating evidence, you mentioned that there is going to be, someone in opposition on this case. What are they bringing to the table when it comes to fact finding and evidence collection, and how should we think about that when we're working on this case?
Yeah, great question. Candidly, usually nothing.
Okay.
The government often doesn't present anything. It's part to do with burdens of proof, right? Like it's your burden of proof to show that you meet the elements of asylum, and it's their burden to rebut them. They usually use your evidence against you as a form of rebuttal instead of providing their own. Lee, any other?
Yeah. Oh, so sorry. For those online, there is a small mic at this table that I am not navigating very well. I would agree that many times DHS does not provide their own evidence at a merits hearing, but will point to articles in our country conditions that might say, oh, but look, this article said there was a pride parade, to which we say, and the second paragraph says the police brutalized the attendees. So, they might try to cherry pick facts, to which we can respond, contextualizing that information. Sometimes they do file some country conditions. In my experience, I say it's less than 10% of the time.
Okay. One other thing that I would flag, I would want to know if Bernadette is still in contact with their girlfriend, and if their girlfriend would also be willing to write a letter of support in this case. Drafting the brief. So this is where you get to shine as the attorneys on the case. When you're drafting a brief, you actually do have to keep it brief. There is a 25-page limit. You cannot go over it. So you want to follow the elements and make sure you're not conflating them. Have every single one very crystal clear, because case law does sometimes conflate them. So we want to make sure the judges don't get confused. Make it super clear that your client satisfies all of the elements of asylum and is eligible. Focus on the Seventh Circuit case law as much as you possibly can, because it's usually better, and send it to us for a review. We'll give you feedback. Preserve all arguments. So when I said file for withholding, asylum, and CAT protection, all of them, and don't waive any forms of appeal. And on that, sorry, the last note is, even if you think your client has a rock solid slam dunk asylum case, you're still going to present briefing on withholding and CAT, so you're not waiving those arguments. What you're doing simultaneously apart from these three things is you're still thinking about, for example, for these secondary forms of evidence, if you have to get them internationally, how are you going to get them from abroad? Things do really get lost in the mail sometimes, so plan ahead and ask earlier rather than later. Connect your client with a therapist. Is it more beneficial for them to have ongoing meetings with one person, or would they have one evaluation? And sometimes these therapists have really long wait lists, so try to contact sooner. Maintain contact, even if you've kind of got your brief ready to go, you have your affidavit drafted, and then say the court kicks your hearing, you still want to be in touch with your client, even if there isn't something pressing, to make sure they know that you still are paying attention and monitoring their case. And then if eligible, file for work authorization or renewal. Work authorization is so important, and folks are eligible 150 days after their asylum application has been filed. That's when they can first apply for work authorization, and that other 150 days they're hanging out and just making ends meet as best as they can. And with that, they will also get a social security number. This opens so many avenues for your client, including housing, sometimes medical benefits, ability to just get a driver's license and not get a ticket for driving without a license, so many things. So it's very crucial to make sure your client has work authorization if they're eligible. And then also keep in touch with your client to see if anything's changed. Have they married or been a victim of a crime or something else that might open another form of relief that's available to them. We hope not, but as we talked about earlier, there are other forms for victims of crimes in the United States. If there are some changes, don't just automatically agree to represent them. Flag us. We'll talk about a new representation agreement if that is applicable. And now I'll pass it back to Lee to close out.
All right, thank you, Katie. We are in the last module of this training, which is presenting the case. And the objective of this section is to just give some practical information about how to file your evidence, how to represent your client in an actual merits hearing. So first, once you've worked through all of that preparation that Katie just spoke about, you will actually file your evidence. So again, we're focusing just on these defensive cases in immigration court. You should have already filed your E-28, which is the appearance form basically saying, I am this person's attorney. And the I-589 will already be filed, whether by NIJC or by yourselves as the pro bono attorneys. About most immigration judges comport with the Immigration Court Practice Manual as far as deadlines, and that is 15 days, calendar days, before the merits hearing. Some immigration judges set their own deadlines, and that's something that we will flag when we pass the case to you. So the actual evidence that you will file includes your brief, the index, and then all of that corroborating evidence, the affidavit, letters of support, the country conditions. So you will file all of that with the court, but you also need to serve it on opposing counsel. Earlier, when we mentioned that there are some electronic cases and some paper cases, most electronic cases are utilizing a system called ECAS. And if you have one of those cases, service is automatic on the opposing party, but you still need a certificate of service saying that you don't need to serve this document because both parties are using this ECAS system, which is a little silly, but if you have any questions on that, NIJC is here to help. If it's a paper case or the case is for whatever reason not on ECAS, then you need to separately serve the government. You'll need to give a copy to the ICE attorneys. I want to flag here, the Immigration Court Practice Manual is a great resource. Also, the NIJC Asylum Manual has a lot of great information on the nuts and bolts of preparing these filings. So how we present this corroborating evidence, I mentioned an index earlier. We'll be wanting to use an annotated index. I know that slide looks pretty small on the screen, but basically you'll want to show, you will have different tabs for each piece of the evidence that you're filing, and you also will paginate. One thing that I want to flag here is to make sure that you review the corroborating evidence with your client. Because I've been in hearings before where the DHS, the ICE attorney will say, well, your mom's letter of support says you were this age when this happened, but you say you were this age. Obviously, you're lying about everything. So, you want to make sure that you're reviewing for potential factual inconsistencies, ideally resolving those with the letter writer, but if not, just knowing and having an explanation. You'll want to check that consistency with all of the documents that you are filing and all the documents that you know of. When you're getting someone's immigration history, if they were apprehended at the border, there is a border interview, for example, and that document may not have been accurately collected. So, there's case laws like Moab v. Gonzalez. There's great case law in the Seventh Circuit explaining maybe when a CBP agent has you locked up, maybe that's not the time that you would have disclosed your sexual orientation. So those are times where you need to know what exists. And then, so that's how you know what to be prepared for. So I mentioned a couple of these points already. So the deadline of 15 days before the merits hearing, unless the judge has set a separate deadline, you'll want to annotate the index. What that usually means is, the Department of State reports are usually 40, 50 pages. You'll pull and highlight quotes of the most important and most relevant information in the index, so it's upfront, accessible for the judge to read. The differentiation between paper and electronic. I had a paper filing today, so it was printed. It had exhibit stickers on it and had tabs on the side. There's I do appreciate the move towards electronic, but there's something really satisfying with the little tabs on the side of the page. Just know that there are certain requirements for those paper filings. The ECAS cases, those are you're uploading a PDF, which I admit is a little anticlimactic, but an extra bonus for that, I guess, is that the immigration court's filing window for paper filing closes at 4 p.m. You've got to get in before then, but ECAS systems, you can file basically up until midnight on that filing deadline. Although I really do not recommend leaving anything to the last minute. You do have a little bit of greater flexibility there. And again, I mentioned that certificate of service. You have to show that you did effectuate service on opposing party. So you filed your case, then what do? You work with your client next to be able to prepare for their merits hearing. So the merits hearing or the individual hearing is the opportunity where your client presents their testimony and the immigration judge will decide whether they're granting or not relief. So I recommend having at least 3 practice sessions in which you prepare your client for a direct exam and also for cross exam. You're not going to know exactly what DHS may or may not ask your client, but you can guess what some of those areas might be. So I recommend having a session where you put on a government hat and you pretend that you're the trial attorney, so that your client can have some experience and maybe a little bit of comfort in feeling ready to respond. I really want to highlight this last point on this slide. Help empower your client to have a voice at their hearing. So if the trial attorney asks a compound question, your client can and should say, I didn't understand that question. And really work with your client so that they feel confident in being able to respond directly to the questions that you've prepared so that they can tell their story for the immigration judge. My wonderful skills of those little boxes just somewhat demonstrates what it might look like in the courtroom. The judge will be sitting somewhat elevated. So if this is an in-person hearing, however, there also might be hearings via WebEx. Try to work with your client. And again, this is a cultural competency piece too, to have eye contact with the judge. So they might have to look up a little bit to make eye contact with the judge or look into the webcam. This is important for credibility. Like Katie had mentioned earlier, client demeanor can be used against them. How do you prepare yourself for the merits hearing? Some of these steps are a little bit of the kind of that practical. Earlier, there was a question about the biometrics being refreshed. This is one thing that you should do in preparation for your merits hearing, just to make sure that they have active prints that they can use to do those background checks. Also reach out to the ICE attorneys beforehand, both to see, do they have the information that you filed, the evidence that you filed, and can you get them to elaborate on DHS's position? Sometimes you can get OPLA, the ICE attorneys, to stipulate or to at least narrow the issues and maybe limit testimony. So that is always something that we strive to do. even if we don't have 100% success rate on actually speaking to that attorney before the hearing. Talk to your NIJC point of contact, get our experience, utilize the resources that we have, both if there are certain idiosyncrasies with a certain trial attorney or a certain immigration judge. So then also, this is another great place. So I want to plug our asylum manual because we have a lot of great information that really lays out what happens during this hearing. There's this initial part where the evidence is admitted, each side can object to the others. Then there's a signing of the I-589, basically saying that it's not a fraudulent case. Then your client gives testimony, direct exam, cross-exam, questions by the judge. If there are any other witnesses, they give their testimony. And then more often than not, immigration judges will allow you to make a closing argument. I always recommend that you prepare one. Then the judge can give an oral opinion or a written opinion. In the majority of cases that I have worked on, it is an oral opinion. So right there in the hearing, they say, I'm granting asylum, I'm denying asylum, I'm granting withholding of removal. They'll issue their decision. Part of that is whether either side would reserve appeal or waive appeal. So when we win our cases, sometimes DHS will reserve appeal. And that means that they would start a 30-day clock in which they would need to actually file appeal if they're going to. They don't always appeal in all of the cases that they reserve appeal on. So don't let that dismay you if you do have a situation where DHS is reserving appeal. But I also say that to say, if asylum is denied, you should reserve the right to appeal. There might be some, for example, in a detained case, if that is one down the road, there might be times in which a client would not want to appeal, but as a matter of course, you would reserve the right to appeal. Let us know right away, and we would talk with you about potential avenues and possibilities for appeal. But after we win, also let us know right away so that we can give referrals to our client on different benefits. So once someone is granted asylum, they have access to other types of aid and of resources. Another thing that you will do with your client after being granted asylum is obtain the I-94, which is it's a technical process, but the I-94 is a document that also shows evidence of asylee status, because people who are granted asylum are authorized to work pursuant to that status. They can apply for a new Social Security card, same number, but the card no longer says only permitted to work with DHS authorization. That language is removed, but they usually need that I-94 card for the Social Security Administration to issue them that kind of unrestricted card. Then you can also refer them back to NIJC for information on some of those other benefits, like applying for family members. So after you win, what are other next steps? You know what you can do? You can take another case. So after you have successfully represented someone and supported someone throughout their asylum seeking process, you can come back to our case list that we update monthly, and then you can identify another case. Maybe you were working on someone from a South American country, and now you're interested in maybe working with someone from the Caribbean. Or there's different particular types of cases that you have interest in representing. Then you can find one on the case list and email my colleague Moises. Email's on the screen. But if you don't see a case that is exactly what you're looking for, let us know. Send us an email. We don't have every single person that we're representing on the case list. So if there's someone that you're not seeing, a type of person you're not seeing, it's likely that we have one as an NIJC client that we would be able to connect you with. What else can you do? You can stay informed. As we've referenced a couple of times today, asylum law in particular changes frequently. And NIJC has some really smart people who work on responses to that, policy publications. You can sign up to receive our newsletter that will help you stay on top of pressing immigration issues. Again, you can check our case lists and sign up to take on a case pro bono. You can contact us directly, and you can also donate. We, as a nonprofit organization, our ability to keep the lights on also is dependent on the generosity of our communities. If you can believe it, that is it for me. So we're having plenty of time for questions. One thing I want to highlight, if you are in person in the room, the QR code on the printed packet is not the correct one. So please use your smartphones to use the QR code that is on the screen. The one in the projected PowerPoint is the correct one. And I am giving you our second CLE code, which is dignity. And I'm going to look so I don't spell it wrong, is DIGNITY, dignity, DIGNITY. So thank you very much for your attention here today. We have about 20 minutes for questions. So if you are in the room that have a question, we can track you down with a microphone. If you're online and have a question, utilize that Q&A box and Olivia will read them aloud to us.
I'm going to bring this back to the very beginning of this presentation, so sorry about that. But whenever you mentioned that like having a criminal history will change like what types of asylum are available, is that criminal history like in the United States or is that abroad? And like if it's in their home country, like how does that change things if they were prosecuted for like anti-LGBTQ laws?
Great question. Yes. The answer is both. So there is different bars to asylum. And if their crime occurred in the United States, it's the particularly serious crime bar. If it occurred in a different country, it's a serious non-political crime bar. So the question of what if they were arrested as a result of like an anti-LGBTQ law, then the argument would be that's actually a political crime, so the bar doesn't apply. But if someone has any sort of criminal history, that is something that you'd have to do that legal argument in the brief for. But so recap is yes, both crimes in the US and outside of the US could bar someone for eligibility for asylum. The rules are a little bit different for withholding or removal, and then different yet for protection under the Convention Against Torture.
Thank you.
Thank you.
I just plug the NIJC resources about past crimes. So we worked together on an asylum case, and we had a client who had some DUIs, and that were expunged, and that's not sufficient to be a past crime. So, work with your NIJC contact to make sure you're using all the right resources to put your client's best case forward.
Thanks for the plug. And I also just want to acknowledge and say out loud that LGBTQ people and people of color are disproportionately impacted by the criminal system in the US particularly. So just because your client has a criminal history does not mean that they have their bad or have done wrong, just to really acknowledge that we're coming from multi-layered systems of oppression. And so there is good law that we can use to say why someone's criminal history would not disqualify them from asylum protection. But also, I want to make sure that we're recognizing the legal systems in the US based in racism and white supremacy.
We have a question in the chat here. Does NIJC offer training on appeals before the BIA? And are there any pro bono opportunities for cases on appeal or perhaps remand?
There certainly are those opportunities. I'm directly working with a team with a case on appeal at the BIA. And I don't think we offer training specifically as to BIA appeals, we'd certainly have resources on them and would provide direct mentorship and technical assistance for those types of cases.
I'll also just mention that the last case that is on the case list that was circulated is on remand from the higher courts, and it's been twice remanded. And so we're looking for counsel to help this client continue to fight what we think is a very compelling case, if someone's looking for that challenge. Just a quick question also, can you talk to a little bit about NIJC clients? Are they mostly in Chicago? Where do they live? You know, like what's our service area for those of us that might live in Chicago, outside of Chicago, thinking about some of the collar counties as well. And then,
Yeah, so NIJC, for the direct legal services, we work with clients in Illinois, Indiana, and Wisconsin. We have quite a few clients who live here in Chicago, but also many folks live in the Indianapolis area, other places in Indiana and in Wisconsin as well. So if you're based in an office location outside of Chicago, you can find people who are close to you. And also, there's a lot of opportunities and a lot of ways that we can utilize technology to be able to meet with clients virtually who may not be within driving distance to Chicago. So both of those opportunities are there to, you know, work with someone in a more underserved geographic location, but also to be able to do some of that work remotely.
Thank you for this presentation. So since many of us here are still law school students at law school, so I just want to know, like, since I summer here, like when I come back to law school, for example, in next semester, is there any opportunities that I can, you know, help with your work and like externalship? I don't know, like how should I reach out to you? Thank you.
Yeah, thank you. To any of the law students here and out there, there absolutely are opportunities throughout law school to support NIJC's work. We do offer internships both over the summer and through the school year. One resource I'd like to plug for that is the PILI internships, PILI. That is a great way to get plugged into public interest work. I mean, of course at NIJC, but also in a lot of other legal practice areas as well. If you speak languages other than English, we maintain a database of volunteer interpreters. So for internal in-house cases for languages that are not commonly spoken among staff members, that can be another way to give back and to work with NIJC clients.
We have another question from the Q&A online, and it is, can you speak a little bit about the nationalities of the clients that you've worked with or that NIJC sees and like the diversity of those clients?
Yeah, we have, I feel like a very diverse client base, and I don't need to monopolize the Q&A at all. So Katie and Moises, if you have other things to say, I know me personally, I speak Spanish, so a lot of my clients are from Latin America, but we have African clients, we have Central and South American clients, there is quite a Middle Eastern clients. There's quite a diversity of the clients that the LGBTQ project specifically sees, and then NIJC writ large. Is there anything else to add from my esteemed colleagues? Okay.
We have a few more questions from the chat.
Great,
Let's
thank
see.
you.
Okay, so one question from the chat is, can you talk more about how you would structure and present an argument based on multiple PSGs, religion, political opinion, and sexual orientation?
Yeah, definitely. So when there's multiple protected grounds, I think of it as kind of each having its own channel in a way. So when I'm writing the brief, I'm like, well, Mr. So-and-so belongs to these 4 protected grounds. Sub A, Mr. So-and-so is a member of the particular social group of gay men from Honduras. And then sub B, Mr. So-and-so holds a political opinion contrary to the Honduran government. Sub C, he is from a minority religion. And then in the next section where I'm saying he was harmed and that harm rises to the level of persecution, I list out all of the things all the ways that he was harmed. And then when I go to the nexus, I say he was harmed because of his PSG. Have that nexus information. Then he was harmed because of his political opinion. What harms were connected to his political opinion? Then he was harmed because of his religion. What harms were connected to his religion? And then the government's unable and unwilling to protect people like Mr. So-and-so. A, the Honduran government doesn't protect LGBTQ people. B, the Honduran government doesn't protect political dissidents. C, the Honduran government doesn't protect minority religions. So being able to separate them out within each element to show that complete line of evidence for each type of claim.
You sound so smart. This is wonderful. This is great. We have one question in the room and another question in the chat.
Do you find, since you only have that limited 25 pages to brief of the particular grounds, are there any that the courts tend to be more favorable towards granting asylum for, or is it pretty even across the board?
I'm not totally sure. What I would probably do is I would highlight what I think are the strongest arguments first. Like, let's say in my made up client, the religion argument, not so strong, the political opinion argument, super strong, and the sexual orientation argument, somewhere in the middle. I might change the order in which I am writing my brief to order them from most strong to a little bit less strong, but still viable. But I don't have a sense that they're like, oh, political opinion claims, those are slam dunks. Any religion claims are super weak. I think that, in the legal framework of asylum law, cases need to be considered on an individual case-by-case basis to avoid these kind of blanket generalizations. But I would structure it with my own analysis of the strength of the claim.
A follow-up question to that is, might that vary by jurisdiction or by circuit?
Yeah, it absolutely would vary by jurisdiction. We were just talking during the break about some of the differences that we see across the country of the, asylum offices in California versus asylum offices in New York. And what we see is within the Chicago Immigration Court, there is a wide variety of grant rates. TRAC collects some data about individual judges' grant rates, so you can see the disparities and the unfair and arbitrary nature, really, of immigration proceedings.
This question is for all panelists. Online, they ask, can you share about how you support a client whose understanding of their sexual orientation or gender identity changes during the lifespan of a case? And how do you share this information with the court?
Shall we start with our panelists?
Sure, I can start. I have had this experience. It is pretty common because folks are finally in a place where they feel safe enough to explore their gender identity and their sexual orientations for the first time. So what they initially might say to you is make their first test of like, is this safe for me to say out loud? And then it might evolve. And just as people who aren't in asylum might evolve their gender identities and sexual orientations. And so it has not yet been an issue on credibility if you can get to the court, and we have judges, luckily, that often do understand that getting to know and understand your gender identity and sexual orientation is a journey, has not been a credibility issue when you provide that kind of explanation of like, oh, I came from a really homophobic society that didn't allow me to talk about or explore these things, and now I'm here and I thought one thing first and now I think this now, and this is how I present myself best. And we have had some clients too who identify as trans but don't feel safe externally presenting as trans, and that's okay too. We've still won cases like that.
Yeah, and I think I would just add again, this I think goes back to the importance of understanding the difference between gender identity and sexual orientation, right? Because going back to what we were talking about earlier, you can't just assume based on someone's gender expression that you understand their gender identity. So I think keeping that in mind will also help you not limit your the way in which you're perceiving them.
Yeah, thanks. I think that the how do you present this to the judge piece, that's where you utilize the affidavit as well, and enabling a client to tell their complete story. And that is, you know, if we're thinking back to that Customs and Border Protection interview where maybe they gave a statement that appears inconsistent, adding in the affidavit, hey, I was tired, I was scared, I didn't think it was safe to come out to the government. So being able to utilize the affidavit as a way to give those kinds of explanations.
Okay, this is your last chance to ask any questions or curiosities that we may have for the team. And one final plug to please complete both of the QR codes for those in the room that are summer associates or those online that are summer associates. Please, I know that CLE doesn't count for you yet, but please complete at least one of those so we can track who's in this room with us today for our funding needs as well. Any last questions online or in the room? Hearing none, happy Pride Month, and thank you, Jenner.
There's a happy hour right outside for anybody who'd like to join.